Thank you very much for asking me here this morning. I think my task is to wake you up if the coffee and the various lattes and cappuccinos haven't succeeded in doing it first, and to set the task of saying, in a very personal way, my involvement with human rights, which sounds quite dramatic. So what I was going to do was going to talk for probably about 20 minutes about what I see as some broad human rights themes, about the HRA and the ECHR, and indeed about how I've come to be involved with it and how I suppose my views may have evolved, and some points about the working of the Human Rights Act, and I suppose at the end of it, why I was beginning, probably, why I parted company with the Prime Minister on this particular subject, and perhaps a few thoughts as well about the future and where we might be going. At which point I will stop talking, we can do Q&A, and you can all decide to ask me questions on the topics which you think I've tried to avoid, and that's probably quite a good way of proceeding. I have to say that I did sit in the tea room at the House of Commons some months ago opposite one of my colleagues who hasn't got a particular interest in human rights, but nevertheless somebody with whom I get on very well. And I reflected slightly mournfully. I said it would be very nice if I could get a life again, because I realised I was probably in danger of turning into a single-issue obsessive. Or at least this might be how the public would perceive me. I didn't go into Parliament with, or indeed get involved in politics, with any particularly strong views on the Human Rights Act or the European Convention on Human Rights. Although I have to admit that there was probably an element of family involvement, because my father was a backbench MP, he was also a lawyer, and he was for a time the chairman of the committee, the legal committee of the Council of Europe, which concerned the operation of the European Convention on Human Rights in the days of, long before, of course, we had incorporated. But I probably did get from him something of a sense that human rights mattered and that the convention was very important. Now, I think it's important to emphasise as well that my father, and I think I, saw this issue of a tradition of rights very much as being embedded in our own national tradition of liberties and freedoms. Something that can be traced back. It's a bit of a mythical narrative, but nevertheless it's an important narrative. Something which could be traced back all the way to Magna Carta, habeas corpus, the Bill of Rights of 1689, the Petition of Right of 1628. Something very distinctly British, or probably more particularly English. I hesitate to say this in the presence of people from Scotland, but it does have a rather important English dimension to it. It's, after all, a very long time ago, but in the Middle Ages, that in the 15th century, that there was an extraordinary man called Chief Justice Fortescue, who wrote a manual for the son of King Henry VI, who of course never got onto the throne because he was murdered after the Battle of Tewkesbury in the War of the Roses. And Fortescue wrote a book called De Laudibus Legum Angliae, in praise of the laws of England, which is an extraordinary celebration of what he saw as English exceptionalism. England was different. He deprecated the use of torture, freedom from arbitrary rule. He extolled trial by jury and praised due process of law, and rather memorably said that he would rather see, this bear in mind is in 1453, so it is a very long time ago, he would rather see 20 guilty men acquitted than one innocent man hanged. And I actually think it's quite heavily embedded in our national DNA. And so my father, as he was sitting in this very rather old-fashioned traditional Tory, as he was sitting in the Strasbourg Council of Europe, I think he saw the mechanisms of the European Convention on Human Rights as being essentially, at least in part, a British gift to the rest of Europe and to humanity in general, in setting out, in written form, what we ourselves, even back in the 1950s, would have regarded as our fundamental liberties, but translated into rights. I think it's right that Dinah Rose, who rightly said, a very distinguished human rights lawyer, that the only Article 8 on privacy can be regarded as being outside the canon of what you would normally associate as fundamental British liberties and freedoms. But equally, it's right to say, and I've also been conscious of this, that our decision to sign up to the Convention in 1950 was not uncontroversial. And there's some very amusing stuff from the time about what was being said. Sir David Maxwell Fyfe, who was a Conservative Member of Parliament and subsequently Lord Chancellor, was very keen on doing it, but there were other people who were much, much less happy about this. There was, despite the fact that it was following on Eleanor Roosevelt's declaration of the Universal Declaration of Rights in the United Nations, there was a Foreign Office advice which said, to allow governments to become the object of such potentially vague charges by individuals is to invite communists, crooks and cranks of every type to bring actions. And the Labour Lord Chancellor, Lord Jowett at the time, was equally scathing. He said the document reeked of compromise and was far too vague. Now, I mention this because 60 years later, it is remarkable how these same themes still crop up over and over again. Think of last year. Prime Minister, friend of mine, and a past colleague, although we're still colleagues, but no longer colleagues in government, goes down to Runnymede and makes a really spifflicating speech extolling the liberties and rights of England and the United Kingdom in a great commemoration which the Queen attends. He lauds the Great Charter, and he also, interestingly enough, is very, very complimentary about the intentions behind the European Convention on Human Rights. But this is shortly after the Conservative Party publishes a paper where, although it says that the Convention is an entirely sensible statement of the principles which would underpin any democratic nation, it then goes on to assert both the recent practice of the court and the domestic legislation passed by Labour, that's to say the Human Rights Act, has damaged the credibility of rights at home. And the Strasbourg Court is then comes in for a great deal of criticism. And that's the origin of the programme of fundamental change that my own party then started to put together when they said that they wanted to create a new British Bill of Rights which would, and I quote, clarify rights, particularly under Articles 3 and 8, to prevent their alleged abuse in respect of deportation by changing the tests to be applied. Also expressed a desire to confine the right to invoke a breach of the Convention to cases that involve criminal law and the liberty of the individual and other serious matters, with Parliament setting a threshold below which no Convention rights would be enforceable. And, most challenging of the lot, advocated breaking the link between our own courts and the Strasbourg Court, getting rid of the Human Rights Act and replacing it with a domestic Bill of Rights, which would then have the Convention text glossed to remove those areas of irritation identified and which would then be interpreted solely by our own courts. And that issue is, I suppose, the one that has dogged my political career in a way that I had not entirely expected. When I was elected in 1997, we were just coming up to incorporation. And I thought incorporation was a really good idea. My reasons were that, as some of you will be aware, in the 5 or 6 years before 1997, there had been a lot of talk about having a British Bill of Rights. Indeed, a convention was set up, which brought together certainly Labour and the Liberal Democrats, although the Conservative Party didn't participate, which was designed to see if we could have a British Bill of Rights compatible with our membership of the Convention. But this foundered, and it foundered principally because I thought that was a very good idea. But some of my colleagues didn't. And I think in fairness to them they didn't, because they were afraid about a supranational principles and our own national judiciary having an excessive power of judicial activism over the way in which Parliament and the executive relate to each other in terms of rights protection. And in a way, that's been the story ever since. We voted, we incorporated, my own party, thanks to Nicholas Lyle, who was the ex-Attorney General but was broadly sympathetic to incorporation, even if other members of the Conservative Party were not. We abstained on, so we supported it and wished it well on third reading. We didn't oppose it. And the Human Rights Act came into being, and ever since it has been working just as the Convention has worked in the last 30, 40 years, very actively to challenge some of our perhaps blither assumptions about whether in fact we are a country which is really rights compliant. I keep on making the point to colleagues, they don't always listen to me, but I keep on making the point to colleagues that you only have to look back to where Europe was in 1950 and compare it to where it is today to see the extent of the transformation that's taken place in respect of human rights. Just consider for a moment. Back in 1950, capital punishment was regarded as completely acceptable. Indeed, most European countries, not all, but most practiced it. Most European countries in 1950 practiced corporal punishment, so the chastisement of children by beating them, or indeed, actually beating adult offenders under certain circumstances. And of course, the vast majority of European countries had very precise laws about sexual behaviour which discriminated very powerfully against those and criminalised those who practiced what was regarded as deviant behaviour. All those things have changed. And as one notices as one looks down the street this morning, society has not come to an end. You weren't banged over the head by a robber as you approached this building, and the fact that there may be lots of gay people all around us has not brought the world to an end at all. And that has come about because of the fact that the court in Strasbourg, and indeed our own domestic courts since 1997, have been able to interpret the Convention as a living instrument. That's to say, to apply to the Convention what broadly they see as societal norms as the Convention has evolved. Now, some of my colleagues are really critical of that. They think that's a really bad idea. They think that an international treaty should not be interpreted in this way. It has to be said it's very much in keeping with a national tradition of how we interpret law. Baroness Hale once famously described how our own law and our own statutes are, she said, ever speaking. They can always be interpreted in a modern fashion. So, for example, an assault and occasioning actual bodily harm, Offences Against the Person Act 1861, can now, psychological harm can now be seen as incorporated within that envelope, which was certainly not intended when the Offences Against the Persons Act 1861 was drafted. So up-to-date interpretation of law is absolutely necessary, because otherwise you'd be having to renegotiate the Convention every 3 or 4 years in order to decide what updates you are going to put into it. But of course it's the case that if you have a convention which is a living instrument, it is almost inevitable that from time to time the judiciary, in interpreting the convention, whether it's at domestic level or in Strasbourg, will occasionally do things which politicians find irritating or think goes too far, or where they feel that they're conferring rights which may be excessive. Of course, the magic of Derry Irving's construct was that, so far as domestic law is concerned, Parliament can always legislate to override or just continue with a law which is thought to be incompatible by our own courts with the European Convention. But it is true to say that when we're dealing with the court in Strasbourg, then in those circumstances, we have a duty under international law to observe Strasbourg judgment. And that brings me, I think, to the second big issue which underpins the current controversy, which I think, and we're seeing it at the moment with Brexit, I don't want to get lured into Brexit, but Brexit and Britain's relationship with the European Union and some of the underlying attitudes that go with it is quite closely linked to this issue also over human rights, which is to what extent does a country like the United Kingdom, which sees itself as sovereign, be willing to accept decisions which are taken externally and accept that it will have to do something about those decisions as a matter of international law. And here we come to one of our great national conundrums, which I'm quite comfortable with, but I realise a lot of my colleagues are not. The United Kingdom has a long tradition of sovereignty. We talk about parliamentary sovereignty, which is actually the fact that the executive cannot override Parliament. Parliament, the Queen in Parliament is supreme over the executive. But some of my colleagues talk about it as if it was the lordship of the universe, as if it gave Parliament, or Britain, had to constantly maintain the fact that it was not subordinate or had to defer to anybody. Now, this is plainly nonsense. I once asked the Foreign Office, some years ago when I was Attorney General, I said, well, can you tell me how many treaties the United Kingdom has signed up to in its history? And they got into a terrible sort of spin about this. They said, oh, Attorney, it's a very difficult question. But they went off and they tried to answer it for me. And they came back and they said, well, we've looked at our records, and since 1834, the United Kingdom has signed up to over 13,000 treaties, which we have signed and ratified. And that consists of everything from the UN Charter, the European Convention on Human Rights, bilateral fishing agreements with the French over the Channel Islands, you name it, it's all there. And about 800 of them have arbitral mechanisms for resolving disputes in interpretation. That's to say that the parties agree that they will go and find somebody else, it could be a tribunal, it could be a third country, to adjudicate in a dispute. That's what the International Court in The Hague is doing all the time on many areas of international law. And of course, we're signatories to that. We're signatories to the International Criminal Court, for example. And actually, the European Convention on Human Rights is no different from that. Not at all. It is simply an acceptance that if there is an argument over interpretation, ultimately the court in Strasbourg will determine what the interpretation should be. So the big question we're facing as this saga has continued, because it simmered right through my time in opposition and then surfaced again in 2008-9, is that some people do not like this idea that international treaty obligation should shape the way in which our law develops in this fashion. I have to say, perhaps it's too much of the lawyer in me, but despite being a good conservative, I am essentially entirely comfortable with it. Of course, if you don't like an international treaty obligation, you can always pull out. Of course you can. You just give 6 months' notice for the European Convention on Human Rights. But for a country like ours, which has spent so much of its history building international obligations because we think it's very much in our national interest that international obligations should be brought together and that countries should observe them to try to make the world a better place. If you're going to start pulling out of an international obligation like the Convention, you really have to start asking yourself some tough questions about what the consequences are going to be, not just for you, but also for all the other countries that are signed up. As I keep on trying to emphasise to my colleagues, if we leave the Convention or we create a Bill of Rights which is incompatible with it, well then in those circumstances we're sending out a very powerful signal to other countries that they might like to do the same if they don't like judgments of the European Court of Human Rights. How then do we improve human rights records in countries like those of Eastern Europe that joined the Council of Europe quite recently, and where in truth the rule of law is very shaky? I mean, look at places like Hungary or Romania or Bulgaria. I don't wish to be overcritical of them, but they're places where people have doubts they're going to get justice, and where we know from the cases currently going to the European Court of Human Rights, actually people's rights are frequently violated because state authorities have no understanding of what basic rights are. So, disabled children will be left to die of starvation or malnutrition in homes, people will be beaten up in police stations, and courts may on occasion be corrupted. How are we going to change that if we are saying that we ourselves are going to pull out and have our own rights structure, even if it works for us? How will we encourage those countries to continue down the path of improving their human rights records? Of course, some of the member states of the European Convention, the Council of Europe, have really bad records, and some are getting worse. Russia, Turkey, but some are getting better. Georgia, for example. I met the Georgian ombudsman, who's called the public defender, but he's there to protect people's rights. And he said, as far as he was concerned, he could not do his job without the convention, because for all the shortcomings of the Georgian government, ultimately they believed in their Council of Europe membership, and their status as a European nation really mattered to them. So at the end of the day, if he said you're in violation of human rights, or the court in Strasbourg found against them, they would respect it, however irksome or irritating it might be. And that's why the big issue, in my view, on the current debate on where we're going on the Human Rights Act is not really about whether we could do better with the Bill of Rights. I'll come back to that in a moment. But whether we are going to place ourselves in a position where we can no longer be full participating members in the European Convention. And the moment that happens, my judgment is our ability to influence human rights development elsewhere on our planet will be substantially damaged, because the European Convention has been the single most effective tool and lever for promoting human rights that we've ever had in modern history. That's the challenge. Now, that's not to say that I think that the court in Strasbourg is perfect. People can make lots of legitimate criticisms of some of the court decisions. I happen to think, on a personal level, the decision on prisoner voting was unnecessary. I'm not saying it was wrong. Some people believe prisoners should have the vote, and indeed, actually, I think there's a very compelling argument for giving prisoners the vote. But I hesitate to take the view that actually depriving prisoners of the vote as part of their sentence is of such importance that it justifies categorising it as a violation of human rights. I think that's much more difficult, and indeed it was a split decision 10, 11 years ago by the Court of Human Rights when it did it in the case of Hearst. And I also think the Strasbourg Court needs to be very careful, because it is an international court, to give leeway to member states in how they interpret the convention. It's called the doctrine of subsidiarity, the margin of appreciation. Countries, national countries, are the countries that are primarily responsible for upholding rights through their courts and their parliaments. But when all that's been said and done, it's also right to say that the court has been a very powerful force in improving our human rights. And just to take a few examples, the court was responsible for getting rid of corporal punishment in the Isle of Man, when we'd already abolished it in Britain. But actually the more important part of that judgment was the effect it had on corporal punishment in other European countries. The judgment in respect of bans on homosexuality in the armed forces, through the convention mechanism, has had a much bigger impact elsewhere. Or even more recently, interestingly enough, and MARPA, DNA retention and fingerprint retention. You may recall that the United Kingdom or rather England and Wales, because Scotland didn't do it, was the only country in Europe which had blanket retention of DNA and fingerprints forever taken from any person who was ever arrested by the police, even if they were never charged and never prosecuted. And our own House of Lords said it's completely acceptable. The Court of Human Rights in Strasbourg said it was not, it was disproportionate. And we changed the law, something which I'd resisted the original proposals. I was delighted that the court in Strasbourg had done it. 5 years afterwards, 6 years afterwards, who have you heard anywhere in this country, even in the pages of the Daily Mail, saying that we should bring back blanket retention of DNA and fingerprints? So the court does do some good, as I keep on pointing out, even to some of my more reluctant colleagues in Parliament. And moreover, the court is going through a transformational process at the moment, because as a result of the much greater dialogue taking place between our own national courts and the Strasbourg court, I think some of the problems that the Strasbourg court has seem to me to be diminishing. We've been really helped by our senior judiciary being prepared to engage. Lady Justice Arden, Lord Sumption, there's a whole host of people who delivered lectures, talks, built relationships, and pointed out where they saw problems with the way in which the Strasbourg court was approaching jurisprudence. And as our courts in this country are rightly very respected in their interpretation of rights, judgments of our own Supreme Court, and it's interesting to note actually that the prisoner voting never got beyond the divisional court in this country, which may actually explain part of the problem when it got to Strasbourg. But judgments of our own senior courts, particularly the Supreme Court, are now very well respected, coupled with the reform process which I helped to do with Ken Clarke, which led to the Brighton Declaration, making the court more efficient, more streamlined, reducing its workload, and getting the backlog of cases down by 100,000 from 160 to about 60,000 cases. A very remarkable turnaround. So, interestingly, as we come to consider the future of the Human Rights Act and our relationship with the Convention, I do sometimes think that people are trying to fight yesterday's battle. And you need to look at how the court is operating and how the Human Rights Act is operating today, not start getting bogged down with what was going on 5, 6, 7, 8, 9, 10 years ago. Because courts, like any human institution, will evolve under societal pressure, just like anybody else. They're not just a monolith which cannot evolve. And that's precisely what's happening. So at the moment, we have a very strange situation here. The Conservative Party has been chuntering away, my own party, that it doesn't like the Human Rights Act. It's worth bearing in mind that Labour, indeed even the Scottish National Party, showed a marked ambivalence to the Strasbourg court's decision on prisoner voting. They certainly didn't put their heads above the parapet to support changing the law on prisoner voting when we had an opportunity at Westminster 3 years ago. They buried their heads and tried to pretend the problem didn't exist because it's not seen as being very electorally popular. But the current situation is that my party remains in government, mired in this desire that it has got to be seen to do something and change the Human Rights Act and replace it with something else. And the original paper, as I say, was something which was going to lead to us having to leave the convention, or put us into straight incompatibility. I now hear stories that in fact there's a lot of rowing back going on, that the changes proposed may well prove to be pretty well minimal, that actually what they just want to do is to tinker around with the wording of the Human Rights Act and try to remove or change, take account of, I'm not sure what they want to change it to, because the court can take account of any jurisprudence it wants. I think it's a statement, actually, of the blindingly obvious. Or that the court wants to get rid of declarations, they want to get rid of declarations of incompatibility, or that they want in some way to change the architecture of the Human Rights Act without making a significant difference to it. But in that case, it's worth asking the question, why do anything? Why change the current system, which broadly speaking seems to me to work quite well? There is an alternative, We could go back to where we were in the early 1990s. We could try to do a genuine Bill of Rights which is compatible with our membership of the Convention. We could bring in those rights like the right to trial by jury, or if we want socio-economic rights, although it would be very controversial, we could try to turn the Bill of Rights into a sort of proto-constitution, perhaps looking at the relationship between the different parts of the United Kingdom. Worth bearing in mind that getting rid of the Human Rights Act presents massive problems for the government in terms of its relationship with Edinburgh, Cardiff and Belfast, because the Human Rights Act underpins the devolution settlements by incorporating the Convention directly into Scots law, the law which governs the way in which the Scottish government, the Welsh government and the Northern Ireland government can behave. And of course there's a problem over the EU membership, but I won't get drawn into that this morning, or we could go on for a long time. But actually, countries have to be adherent to the Convention, in my view, to be participating members of the European Union. But that may not matter after the 24th of June. It all depends on how you in this room decide to vote. But my view remains that my party has got itself, I think, into a bit of a hole. I think we are failing to see the benefits. We're placing too much emphasis on the drawbacks, which you'll get again with any law or human institution, and we're failing to see the massive good that comes out of the Convention. And that's why my life has become dominated by this issue, and why I parted company with the Prime Minister in 2014, because I was gently trying to point these things out and getting a lot of pushback from colleagues who wanted to do something different. I personally think that this is a debate which I think is now finally going probably in the right direction. I'm quietly optimistic that the end result of all this may well be that we keep the Human Rights Act and we certainly stay adherent to the Convention. I sense the change. That's largely due to organisations like Justice and the hard work they've put into it, and indeed many, many colleagues in the legal professions who have also really hammered this point home. But coming back to where I started, it would be nice to get a life and to start doing something different. But in the meantime, I'm very happy to continue banging on about it because I think it really is important. I mean, it defines for me the sort of country in which I want to live, in which I want my children to live, and hopefully one day my grandchildren. I think it really matters. We live in a difficult, dangerous and nasty world. Let's be absolutely clear about this. When I look around the region in which we're citing, whether it's Russia or the problems coming out of the Middle East, there are huge challenges for maintaining civilized human society. Europe is a beacon in this respect. Of course, there are other places like the US and Canada and Australia and New Zealand and other countries. But actually, we are, as a collective entity, absolutely at the forefront of trying to keep those standards and maintaining people's quality of life and human decency. And we should really keep that in mind because it's under threat, it's under challenge, but if we're firm and resolute in this, these rights, these liberties are so important, and they're so important to all these people who are flocking into Europe at the moment as refugees, that they will ultimately triumph, but they will only do so if we're prepared to stand by them. Thank you very much.
I'm sure you'll all agree that was fantastic. Now, we hope that whatever Dominic does next, he keeps banging on about human rights. We will too. I think we're both going to be working quite actively on the Investigatory Powers Bill, which, although it might not have human rights in the label, has a human rights argument running straight through it. But we do have 15 minutes for questions. Dominic's very kindly agreed to stay with us, take some Q&A. So who's got a question for Dominic? So we've got one there. Anybody else? No, let's take one first.
You've obviously said that the decision in Hurst, the person voting was one with which you disagree as a matter of law, and obviously you intervened in a later prison voting case. But presumably you're completely behind the concept that if you disagree with a court decision by which you're banned, you should follow it in any event. have you found a lot of difficulty in persuading ministerial and parliamentary colleagues to accept that notion that you can't simply ignore a court decision by which you're bound simply because you don't like it?
Yes, I think I have to accept that I have. Firstly, you're absolutely right. I mean, as a lawyer, if we decided that we could ignore adverse judgments, anarchy would reign rather quickly. No, we have to accept the judgment in Hurst. I mean, I did try and go and argue in Scopola to give the court an opportunity to row back, and indeed they did row back a little bit, but not quite as much as I was rather hoping. And I've always seen, I'm afraid, the prisoner voting judgment as a bit of a red rag to a bull. It touches, it's wondrously peripheral in many ways, and yet it's one of those symbolic things which makes people upset and sends the Daily Mail into a hysterical froth. I mean, you only have to read the newspaper to see the effect it has. So it was very foolish, if I may say, of the Court of Human Rights to take on this particular issue. But that having been said, yes, of course the judgment needs to be implemented, and it can be implemented very easily. The amount of change we need to make to our own domestic law to bring it in line with the court judgment probably requires only giving prisoners convicted to under 6 months the vote. That's all that's being asked of us. Or you could say prisoners in the last 6 months of their sentence as part of their rehabilitation. And this idea that rapists and murderers, with long tariffs are going to be voting, nothing in the judgment requires that at all. So yes, of course. Then you come to a very interesting issue, which is about obeying international court judgments. This does worry me. I mean, I can't escape it. As Attorney General, one of the principal roles of the law office of the attorney is advising the government on international law. Indeed, you probably won't be surprised to learn that it constitutes by far the biggest part of the attorney's advisory workload. That and constitutional law, but mainly EU law and human rights. EU law, human rights and international law. And for obvious reasons, international law is often quite difficult to interpret. But the United Kingdom government has a long policy of obeying international law. It's sort of absolute fundamental plank of what I call the UK's ethical attitude to the world. We respect our international legal obligations. We will always try to act in conformity with them, and we will always try to ensure, where there are areas where there isn't a court telling us what to do, that our own legal advisors have signed off anything that we do as being lawful. So, for example, taking military action in Libya, just as a sort of example to you. Now, that really is important. It used to be in the Ministerial Code. It actually said in the Ministerial Code, the United Kingdom, its ministers and its civil servants will obey its international legal obligations. And it was, I think, symptomatic of the problem that last October it was taken out in the new code issued by the Prime Minister after the general election. No sooner had they taken it out and it was queried that the Cabinet Office said, well, it doesn't make any difference, it's just a textual simplification. We still accept that we are bound to obey our international legal obligations. But I have to say, being a little Freudian at the moment, I think it was quite significant, because I think it was an issue that had caused quite a lot of irritation to some of my ministerial colleagues over time, to be reminded that this was an absolute fundamental plank of the way the UK operates. Fortunately, I don't think that we are about to tear it up. But the fact that the government has consistently refused to try to tackle Hurst is, I think, quite significant of an increasing willingness to behave in a rather slippery way about international legal obligations. And of course, one of the things that was being floated in this British Bill of Rights was the suggestion that no international legal obligation could be binding upon us unless Parliament had in some way approved the government making it binding. And it sounds rather, this is all about the Parliamentary Sovereignty bit. Well, it's true that, of course, we can't change the law on prisoner voting unless Parliament's prepared to vote on it, and in fairness to the government, they may still have quite a problem getting that through Parliament, although perhaps less of a problem than they had 2 years ago or 3 years ago. I think it could probably be done now. But you can't hide behind that, or hide behind Parliament as a reason for not, as an executive and as a government, respecting your international legal obligations. So I think I have to accept that this has become a topic of debate, but before people start getting gloomy about it, or happy about it, my personal view is that for the United Kingdom to depart from this standard would be so seismic that it is not going to happen. But it's precisely because people must be aware of this limitation that they ought then to be much more realistic about how we should be going about our business in respect of the European Court of Human Rights. Sorry, rather a long answer.
Can I ask anything? I can see there's a couple of hands. We don't have roving mics, so speak up. And you know who we are. When you introduce your question, tell us who you are. So I've got a colleague at the back.
Hi, I'm I get the impression that the Tories have realised that the Bill of Rights is going to be a hassle. It's going to be a lot more difficult than they realise. But given that it's a manifesto pledge, would you say it's inevitable as a result of that?
I agree with your analysis. I think that the penny has dropped, that it's much more complicated and difficult than was appreciated. I think Michael Gove has appreciated that. But you're right, it is a manifesto commitment, and the Prime Minister has rather personally committed himself to it on a number of occasions, and perhaps I could say that when there have been opportunities when he might have stepped to one side and gone in a different direction, he's always gone in the same direction. It's therefore difficult to see how they can escape completely doing something about it. As you're probably aware, there was talk of it being announced when the Prime Minister came back from Brussels, although it started to get bound up with something slightly different, which was a Bill of Rights which fended off the European Court of Justice in Luxembourg as much as the European Court of Human Rights in Strasbourg. And I think that was to try to get Boris on side. But it didn't succeed in getting Boris on side, and therefore its purpose disappeared, which is why I think it's now quite clear we'll get nothing till after the June referendum. But I certainly don't think we're going to get nothing at all. To do that would require the Prime Minister to publicly accept that he's now thought again about the matter and has come to the conclusion that there really is no national interest in going down this route. And I think I have to accept that that's going to be quite difficult for him to do it, although I would be very happy if he were to do so. It's just possible it could happen. Or it may be it just gets deferred and deferred and deferred, which is another thing which happens in government when you take a decision which turns out, or make an announcement which turns out to be difficult to implement in practice. So I think we may end up with something. And if I may say so, this is going to present a bit of a challenge. Because if it really does turn out to be an almost entirely cosmetic rewriting of the Human Rights Act into a British Bill of Rights, then quite a few of my colleagues who I think probably don't support this may feel out of loyalty, and understandably, that they perhaps ought to support that in order to try to bring this debate to a satisfactory conclusion. Indeed, I have to accept I would have to give some thought to that as well. But really, my bottom line has always been I will not have a Bill of Rights which is incompatible with our convention obligations. That's very simple, actually, to see whether it's going to be or not. And I think that's probably quite a good way of approaching it.
I think we had another question in the front.
Hi, my name's Rima. I was called to the bar 2 years ago. You've obviously had a career that you've constantly had to use your brain. What do you do to wind down?
Oh, great question.
Great question. What I do to wind down? I like the outdoors. I try to get up to Scotland. I'm going up to Scotland for 4 days after Easter. I shall go walking in the hills, in the Highlands. That's probably what I like doing best. I like the open air. And in summer I have a house in Brittany, so I can go and swim and scuba dive and things like that. Apart from that, I have a rather mysterious, I'm not quite sure, I acquired this as a student travelling around Turkey. I have a great love of textiles. So I buy rugs and also hangings, or I like textiles, because textiles are very beautiful and they're also useful because they keep you warm, or they keep your feet warm, or they cover your bed, and paintings are very nice, but so I like textiles. So if I can get an opportunity to go and look at textiles or buy textiles, then that also keeps me occupied.
And I think one of our colleagues was up at the back. Yeah. I don't know which of you. Yeah. No. Our colleague there. Thank you.
My name is also Fatima. I'm currently doing the LPC. My question relates not such a subject, the topic of extraterritorial applicability of the convention. I've heard a few people say that's their issue or their query with it. Example, so the case of Afghan after the Iraq War, and now another example in terms of how it applies in piracy. Does it apply once a pirate has been detained, or is it from when they're under surveillance with some sort of weapon targeting them? And the arguments I've heard for why people are uncertain about it is just how does a country then behave internationally when it's not quite sure whether the convention would apply, and therefore just creating policies to act in that area are quite difficult. What's your response to people who query that side of things?
My response is that they are right in the sense of highlighting that this is, I think, a difficult area. And when I was attorney, I had to grapple with this. Probably worthwhile just thinking of a couple of basic principles. I don't have great difficulty with extraterritoriality, where a country is exercising control. If we were to depart from that, then it would mean, for example, that the European Court of Human Rights would have been quite unable to try to do justice towards Greeks who had their property expropriated by Turkish military action in northern Cyprus, one example. Armenia and Nagorno-Karabakh, Armenia and Azerbaijan. Or indeed, I suppose, Russian behaviour in the Crimea, where after all, in flagrant violation of international law, they have annexed a part of the territory of another sovereign state and are exercising power and jurisdiction within it. So I've always seen, some purists would say, well, actually anything that goes outside your borders should not come within the ambit of the convention. I disagree with that. What I think has proved much more controversial is that the Court of Human Rights has started to look, as perhaps courts inevitably do, at the relationship between behaviour in conflicts outside your territory and your duties under international humanitarian law, which is essentially the Geneva Conventions. And I must say, I'm not wholly without criticism of the way in which the Court of Human Rights has done this, because it seems to me that it has tended to muddy what had previously been rather clear rules about how countries should behave when exercising armed force abroad. That said, it's also worth bearing in mind that the circumstances in the way in which we exercise armed force abroad has changed so dramatically. Historically, you invaded another country, or you had your military forces in another country during a state of war. Nowadays, our involvement in military operations abroad may be under the ambit of the United Nations. It may be even more difficult at the request of the foreign country concerned. So Afghanistan, our troops were essentially there to help the Afghan government. But of course the Afghan government didn't meet many international human rights norms and standards. The classic conundrum that came out of that was, what did you do when you arrested or detained a Taliban commander? You were only allowed to detain him for 96 hours under the international agreement with the Afghans. You couldn't hand him over to the Afghans because you thought the Afghans would torture him, and yet if you released him out of the front door of the military base, he'd probably be firing a rocket at you within 24 hours, and rather bizarrely, you'd then be entitled to kill him. There are some quite complex issues that come together here. My personal view is that I think there's been a greater acknowledgement in the recent Strasbourg jurisprudence that the issue is more complex and that the human rights of the Convention needs to be read alongside international humanitarian law standards. But I don't think we need to pull out of the Convention to solve this problem. We can derogate something which, bizarrely, the UK government's very reluctant to do. I think it's the result of Belmarsh, actually. Belmarsh, if you may recollect, was a derogation. And, of course, the House of Lords said it didn't meet the standards for derogation at all. So I think there's an acute sensitivity within government that they might lose such an argument. I think there may be an excessive anxiety. Or indeed, we may actually have to do some work with our colleagues in Strasbourg about crafting together an addendum to the convention that covers this properly, but it doesn't require withdrawal. And a lot of people who argue that this is leading to a plethora of claims against the military are, I think, wrong. There is a great increase in claims against the military, but actually these have very little to do with the European Convention on Human Rights, and much more to do with the fact that Crown immunity has been removed from the Crown's actions, both in terms of being sued by members of their own armed forces or being sued by other people. So I think it's a very complicated issue, but it's right. I think that those of us who want to keep us in the convention have got to do some hard work about explaining how we can resolve this issue within the convention umbrella. I'm pretty confident we can.
Can I ask, I'm sorry, we are now at almost 10 past, so I'm going to have to draw that to a close. No, we could keep you all day, unfortunately then we wouldn't get any coffee. I'm going to say, can we please say thank you very much to Dominic in the usual way.